dealing with the first point that my Lord raised about the Traffic Management Act and the meaning of traffic. So Section 31, which is the interpretation, it does say that traffic includes pedestrians. I have a hard copy if that would be helpful.
Yes, I would like to see that. Does it mention cyclists?
It doesn't. It just says includes pedestrians.
Yeah.
I haven't done a full research, but this is
While we're waiting, do you want to carry on?
Yes, I could do that. My Lord, I was in the officer's report, and it was pay SB 491. We just looked at paragraph 7.9, which is on the page before, which just says what the Road Traffic Regulation Act 1984 requires when traffic orders are made. And I'm going to come back to that act to just deal with what that is. Then 7.11 is where we have the wider statutory duties are being set out there, and that is the 122 of the Road Traffic Regulation Act 1984. We don't have that in the bundle, but that is where, again, the duties are set out, what needs to happen. Then the second bullet, any duties under the Traffic Management Act, 2004, and the third bullet is equalities. So these are the three main legal requirements that have to be considered, along with the question of the GLA 1999 Act. And just going back to show how this has been taken into account, if my Lords could just turn back to page SB 472 in the same report. Paragraph 3.25, for example, you have the response there from the network management team, and it makes it clear there that there's a network management duty, statutory responsibility. Tower Hamlets is the traffic manager, and then you can see at 3.27 that the network management team would support the removal of livable streets because it would alleviate negative post-screen impacts and improve the resilience, it says, of the road network. And just by way of example, you can see where that is part of the data. Page 476 in this document. Paragraph 340 talks about there were some streets, so part of the analysis, the evidence, shows that there were some streets which saw increases in traffic through this, because that's to do with the displacement that's referred to, displacement of traffic into side roads. And you can see that at paragraph 3.37, there's a table. And if my Lords look at Horatio Street and Ropley Street, for example, you can see the change in traffic flows in those side roads. So this is an exercise undertaken specifically to look at the impacts of the scheme, and that is an entirely legitimate duty. And that's part of the interplay of these various legislation. Now, dealing then with the next part of the submissions, I mean, in essence, the appellant and the interested parties' contention is that not only must you implement, but you cannot remove. If you remove, that's part of failing to implement, and that would be a breach of Section 151. That's the case. Well, that is entirely wrong for a further reason. if one looks at the process by which these TROs were made in the first place. So the very TROs, the very livable streets, roads that are being sought to be removed by Tower Hamlets themselves were implemented by experimental orders. Now, experimental orders are just that, they're experimental. It means that at the end of 18 months, after reviewing them, if they do not meet the tests or meet the requirements, or there are good reasons to, they will lapse. That in itself demonstrates that there cannot be some requirement to implement and never remove them. And we can see this from the Act. My Lord, this is the Act that Your Lordship, my Lord Justice Singh was referring to. It's the Road Traffic Regulation Act, tab 1. And it's section 6. Talks about the orders themselves. But then if you turn over to section 9, that's it, AB6, these are experimental traffic schemes. So there are two ways to make these orders. They can either be permanent or they can be experimental. So 9, experimental, is the provision under which the livable streets, neighbourhoods were implemented. It follows, therefore, that there was every expectation that those schemes...
Sorry, just so as I'm clear, you're relying in particular, I take it, on subsection 3. Shall not continue in force.
Indeed, my Lord, indeed. There is authority on this, that experimental traffic schemes must be genuinely experimental. There has to genuinely be the possibility that they will lapse. They don't need to lapse. In this particular case, they were then made permanent. But the point is that they will not continue in force for more than 18 months if they don't. So that also exposes the fallacy in what the appellant and the interested party are saying here. These very schemes were put in through an experimental order, which must mean that there was a contemplation that they would not be made permanent, and therefore they would be removed.
How shall I follow that?
My Lord,
The LIP says, putting it in very broad terms, says we'll do all of these things, which may involve the use of traffic regulation orders as part of it. The way they implemented that, or I won't use implemented, put it into effect, was in the first place to use temporary experimental orders, but then turn them into...
They turn them into...
So how does that help your argument?
Yes. Well, it helps it in this way. If the suggestion is, well, the submission is, that in order to implement the LIP, it was necessary to not only implement, but also to retain, that's what I understand, and that you cannot remove the scheme unless you amend the LIP. That seems to be the way that the argument is being put. That is not consistent with the wider statutory scheme that I am referring to. So it's testing whether that can be right. The method for implementing a scheme can be either by way of permanent or experimental. The Council has powers to implement through the experimental provisions of the Act, 1984 Act. And those experimental powers contemplate, they have the legal power, that they may not retain the scheme. So that power is not overridden by the GLA Act 1999. That's the point. There's nothing that says you cannot implement by way of an experimental order. And these legislative provisions have to be looked at, they have to be worked out together.
That seems to be an argument for saying that, taken to its logical conclusion, that LIPs will only last for 18 months.
Well, no, not LIPs. I think this is where the confusion arises. The LIP is a huge document, and my Lord has our LIP in the documentation. It's got many, many schemes in it. The question here is, it's not that the LIP lasts 18 months, it's whether the schemes that are subject or are in the LIP, how are they to be implemented? Now, they are not, it is not the case that you just say, here is the LIP, here are schemes, in they go till 2041. That's simply not how the legislation works. And that's why it's wrong to suggest that the 1999 Act somehow trumps everything else, or that the mayor has got all the authorities in a straitjacket. That fails to understand the legislative context, which includes, and has to include, how you implement any of those schemes. One of the ways that you implement them is through an experimental order. That power remains for the council. The council always has and is the power to implement through the TRO, through experimental or permanent. If it's experimental, which is what happened in this case, it could have been removed under the 1984 Act. That means that it is not correct, when you read them together, to say that you cannot ever remove them unless you revise the LIP. I don't know, my lord, if that makes the point a bit clearer. Then, just looking at what the GLA Act actually says, it also doesn't say what my opponents have been submitting. If one just turns to the Act, that's in the authorities bundle, and it's at tab 2. I mean, as your lordship pointed out, there are a whole series of provisions here that relate to the mayor's own strategy. And just looking at 142, which is at page 17, that's the strategy, and you've been taken through all of these provisions. And then working all the way through to the actual LIP, it's 151 at page 21. And this is where the mayor has approved in an implementation plan a LIP, and we know that the mayor has approved the council's LIP, or one that's been revised. It then says at A, shall implement the proposals contained in it in accordance with the timetable included. If it's not implemented, or the mayor thinks that it's failed to be implemented, the mayor has got powers to implement it himself, and that's at 152. And then at 153, the mayor can also issue directions. But the mayor obviously has a discretion whether or not he wishes to do that. He's got these powers, but he has a discretion. Now, what is being said by the appellant is that 151 in and of itself means that the council must implement these proposals, and once they're implemented, they can not be removed unless the LIP is revised. But first of all, the problem with that is the public law context, which Mr. Justice Fordham also raised and was discussed before in the High Court as well. The public law context, which I touched on earlier, is that there is a whole consultation process which has to be undertaken before you can make or implement any of these orders. That must be done with an open mind. It cannot be the case that the consultation is fettered by 151. That would go against the entire purpose of the consultation process and the entire scheme of making TRO orders. So it cannot be predetermined that a TRO will be made.
So, can I understand how that works analytically?
Yeah.
I mean, I understand the point you're making, but how does that fit into the statute? I mean,
yeah.
Do we read section 151 as somehow subordinate to a common law duty to consult? And if so, how?
Yes.
Because it's parliamentary legislation.
Yeah. Well, my lord, it's parliamentary legislation, but so is, of course, the 1984 Act, which is the basis for the consultation. So that's not just a common law duty to consult. It's a statutory requirement to consult.
Have we seen that duty?
Yes, I think we have got that in the bundle. We have it in the bundle. We also have it set out very pithily in the judgment.
Wherever you want to go.
I think the judgment first, and then I will ask my senior behind me to just find out what that is. So it's at paragraph 10, page 26.
Yes.
I don't know if your lordships just want to run an eye down there, but the relevant sections and regulations are set out there.
Well, there's something you can draw out, which says there's a statutory duty of consultation.
Yes,
in making.
Right. So as I said before, there are two types of orders. There's the ETO, which is the experimental order, or there's the permanent order. The temporary order has a consultation process that takes place in the 6 weeks. Yes, so the experimental order does not have the same consultation process. You can just put the temporary experimental order in. This is why these schemes gave rise to so much controversy, because they were mainly put in during the COVID period, and they were done without the consultation on this experimental basis. But then after that, you have a further order, which can be made to make it permanent. Otherwise, it'll lapse. But in order to make it permanent, then you have to make it under the section 6, regulation 6. And that one is the one that's got a 6-week public notice and consideration of objections. That's regulation 7, 8, and 13. And so you have to take into account all of that consultation before you can actually make the order. And I think we do have these regulations.
Yeah.
It's tab 29.
Of the authority.
Of the authority.
Right.
All those regulations are there.
I
So to answer my lord, these are statutory requirements. They're not common law.
It's page 29.
Oh, page 29.
So these are statutory requirements to undertake that consultation.
Yep.
That's why Mr. Justice Fordham makes the point that there is a public law context. And that's no doubt why he was concerned about the question of how this is to be implemented, how is this to be enforced. That's why. Because clearly it is not really in the hands of anyone to implement and retain, to implement at all, in fact, or to retain. Because if the consultation elicits reasons why the orders should not be made with an open mind, then it will not be made. And that is something that my learned friend Mr. Parker recognises in his skeleton argument. He addresses that point. It's skeleton argument, and it's paragraph 33. And he obviously recognises the difficulty with his position.
I'm not seeing that, I'm afraid.
Paragraph 33.
Yeah, I have the paragraph. I don't see the point you're making.
Maybe
I may be missing it. That's why I ask.
yes, but I was going to the paragraph myself. So it's sorry, it's not that one. It's quite right. 32.
Right, thank you. But,
No, that's not it either.
no, I don't think that's really meeting the point of substance.
That's not the point, my lord. It's
I mean, it's all very well. I don't mean this critically. It's fine.
my lord,
to
it's
be...
sorry, my lord.
No, carry on.
My lord, it's paragraph 35.
Oh, right.
And it's little Roman 3.
Right. Thank you.
In fact, it's the whole of those little Romans 1, 2, and 3. The point is made that.
Right.
And little 3, the possibility that schemes may not be implemented at all is canvassed precisely because it may not be possible to implement the schemes in full where there is no public support for them.
Yeah.
It has not been possible to redesign them. If that were to recur in the case of a scheme within the LIP, which is not in this case, it may not be a breach of duty where the scheme has not been implemented.
Yes.
So there's a recognition of the fallacy and the difficulties with the argument Because obviously it's not being said that this should only occur in this case. It's being said that there is a statutory requirement, a duty, to retain. That must mean all schemes. It can't just mean Tower Hamlets as livable neighbourhood scheme. So there's a recognition there that there is a genuine problem, that if the public consultation is to mean anything, they may not be implemented, and it may not be possible to do that.
But could that have the consequence that the LIP needs to be revised?
My Lord, it could or it could not, because the only time that the LIP, I think this is a good time to go to the LIP provisions actually as well. The LIP does not have to be revised unless, in fact, we can look at revision. It's 148, my Lord, of the 1999 Act, page 20. And it says, a London Borough Council may at any time, prepare such revisions as it considers appropriate to the Council's implementation plan. Now, that is not a requirement. It's just if it's considered to be appropriate. And if we look at the guidance, we've been given some guidance.
Sorry, before we leave the statute,
yes.
As you know, depending on the context, sometimes the courts have said that may means must.
Yes.
If that's the only way you can comply with some other legal obligation, then it may be that you have to exercise.
Yes. Well, maybe, but if one takes that argument further, you're only supposed to change the lip, and I'll take you to the guidance, where there's a significant change in strategic direction.
I see.
Or for objectives. The removal of one scheme in the entire lip is entirely disproportionate basis for making revising the lip. And your Lordship knows that the lip revision process is onerous. It again involves the entire consultation, all sorts of different bodies, approval of the mayor. So the idea of doing that for one small scheme is not right, in my submission. And that is a point that was canvassed in the court below, where Mr. Justice Fordham did ask the interested party, well, are you saying that if you remove some boulders, you'd have to revise the lip? And the response was yes. And that is, in my submission, completely wrong. And that is supported by the Mayor's own guidance, in fact.
Yes.
If one turns to that, that's in the supplementary bundle. My Lord, it's tab 2 is the Mayor's guidance for lip preparation, and it's page 40.
Page
40.
Right.
So this is the Mayor's own guidance.
Yes.
And there's a section on revision of lips, paragraph 140 on page 40, SB 40.
Yeah.
And it says here, a borough may revise its lip at any time if it considers it appropriate.
Yeah. Well, can I suggest what might be a significant change in local circumstances, which is that we've tried to implement this as it was. We had a consultation, and the public said, no, we don't want this. Why isn't that entirely apt to fit into that description?
That would, as a significant change in circumstances.
Yeah.
Well, my Lord, it might do, but the question here is it's not mandatory. The point that's being put to your Lordships is that you cannot ever not implement your scheme, and you must retain it as well. That's what's being tested here. We're not saying you can't revise it. Of course you can if you want to. But it does say here it's a matter for the council as well to revise it if they consider it necessary. But it's generally considered to be something that's required if there's a significant change in circumstances. And as I've pointed out before, the LIP itself contains many different schemes. This is but one of them. The other consideration is, it's been said by the appellant and the interested party that the council cannot go against the mayor's strategy, his transport strategy. Well, the council doesn't consider that it is going against its strategy. It's made that point very clear. It doesn't consider it is. There are many different ways to skin a cat. They don't have to be through low-traffic neighbourhoods. And, my Lord, that's clear, again, from the strategic plan that the council has prepared. And, my Lord, you can see reference to this in supplementary bundle the witness statement that my own friend took you to earlier. That's at tab 19.
Scheme, sorry, I don't want to interrupt. I have interrupted you, and I
That's all right.
apologise for interrupting you, but isn't the scheme of the Act that it's not up to the local authority to decide whether it's complying with the mayor's strategy? Because the local authority has to put forward its plan, which the mayor then decides whether to approve or not. So it's not up, I'm putting it in very, very colloquial language.
I understand.
Here, but it's not within, I'll put it in slightly more formal language, it's not within the sphere of decision of the local authority. It's for the mayor to decide whether it approves the plan, and then there's a duty under 151 to implement it.
Yes. But then it goes further, doesn't it? Then there's the question of whether you revise it or not. And that's 148, which does allow the local authority to revise it. The local council may at any time prepare such revisions as it considers appropriate. And then if the mayor disagrees with that, or he's unhappy about that, he with 150 can direct or prepare such revisions himself. But he hasn't done that here.
You were going to show us a witness statement.
Oh, yes. It's tab 19. And page 2 onwards, paragraph 4 onwards, is dealing with the question of the
So
mayor's transport.
paragraph 4.
Sorry, my lord, paragraph 6 onwards.
6.
So, my lord, two things have happened here. One is that in the intervening period, obviously the 3-year delivery plan has expired. There's now a subsequent delivery plan that has been approved by the mayor, and that doesn't contain any of the livable streets or the lovable streets in it. So there's no question in that document of anything being implemented or put forward, not something that the mayor has objected to. And then paragraph 11, you can see the council's position, why there are 2 reasons why the council can remove the scheme. And this makes the point about it being disproportionate in terms, in a case where the council's overall strategic direction has not changed. And that is reflected in the council's current strategic plan, 2022-2024. That had been in the interested parties witness statement, that plan. It's not in the documents. I don't think your lordships need to have it. But it sets out the strategic plan, which addresses all of the mayor's objectives. So it's just about doing it in a different way. Council does not consider that it has changed its objectives. And of course, it's retaining the Wapping and the Isle of Dogs plan, and it has many other schemes within it. And the second point is that a requirement for a revised LIP would mean a revised delivery plan in circumstances where the mayor has already approved the delivery plan, which doesn't include any of these schemes.
Did the judge make these points in his judgment?
My lord, the judge has, I think, made these points.
I only ask because there's no respondent's notice, so it's the judge's reasoning that you're defending, as I understand it.
Yes, I don't think I'm going against anything that...
Well, that may be right, but,
Yeah.
but if there's anything the judge said about these points...
They were rejected by the judge.
Like, I thought, maybe I've completely misunderstood your case. I thought that there was a point of law
Yeah.
that you were making, which the judge did accept,
Yes.
which is that implement doesn't mean retain.
Yes. My lord, I was actually just dealing with my lord's point about revisions and whether it's necessary, and your point, my lord,
Yes.
which was that you might consider there to be a significant change. And I was making the point that...
No, I'm not criticising.
No, that's the reason I went down that
No,
road.
that's fine. As I say, I'm not criticising, all right? It's fine. Just trying to understand the submission. Are you making a submission that there has been no breach of section 151? So can I just finish? There's no breach of section 151 because, in truth, the London Borough of Tower Hamlets hasn't done anything which is inconsistent with the Mayor's strategy. Because that's a different point, if I may say so, from that implement does not mean retain.
No, my lord, it's the latter. It's that implement does not mean retain.
I see.
The earlier points, I was simply trying to assist the court
I see.
with questions that your lordship had raised.
Right.
And I'm sorry if they were not helpful.
No, that's very helpful.
Yeah. But no, the council's case is exactly as it was before Mr. Justice Fordham, the case that he accepted.
Yeah.
And that is simply this, that there is no obligation whatsoever to retain, and to retain would be inconsistent with the legislative context and inconsistent with public law duties to take into account the statutory consultation, because that would be to prejudge the removal of a scheme in circumstances where the council has the power to make those orders and has got a traffic management responsibility as well.
Yes, but you've made those submissions very clearly, and we understand.
Thank you. One of the other points to make relate to the objections made to his lordship's footnotes. My lord, it is obviously relevant that the interested party has never taken these points about any of the other schemes that have been removed across London. These include Brent, Ealing, Greenwich, Kensington and Chelsea, the Brick Lane scheme in Tower Hamlets as well. It is entirely, in my submission, disingenuous to suggest that it is a matter of great concern just for these schemes, but somehow this duty to retain didn't apply anywhere else. Well, that's also pertinent because TfL responded to the consultations, and Mr. Justice Fordham, again, makes that very point, that in none of the letters to the council did they say, well, hang on here, there's a showstopper, you'll be in breach of section 151. That's simply because that duty doesn't exist. It's not correct, it's a misinterpretation of the Act. Otherwise, it's inconceivable something that is so significant would not have been mentioned in any letter whatsoever. Yes, and then the other point that's taken against the judgment below is that the judge shouldn't have had any regard to the timetabling issue. Well, that's obviously wrong, because whether or not the scheme was, although implemented, it's, on the one hand, the interested party and appellant say it is implemented, but on the other hand, say it isn't implemented because it's not retained. It was right for the judge to test that question against the question of the timetable. Because again, it's not just about this scheme. They are putting forward for your lordships a proposition that it is a legal requirement to implement and retain the scheme. So that must apply to all schemes, and it is right to test the approach in that way. So there's no error there in my submission. The final point on that, and going back to the question of retain, there is nothing in the legislation that uses the word retain. If there was a genuine requirement to retain, even though, as I've submitted, that would be contrary to the other duties, you'd expect the Act to at least say that. It doesn't say that. So I'm going to move on to round two.
Yes.
Yeah. So this is the contention that the Mayor's strategy wasn't taken into account.
Yes.
Your Lordship has the skeleton argument on this, and also the comments of Mr. Justice Fordham in his judgment, which make it clear that Appendix D of the officer's report, and we can turn to that, it's in the court.
Should we go to that now?
Yes, we can go to that one.
Right, thank you. And where is that?
251.
251.
No, 551.
551.
SB 551.
Oh, sorry, it's in my other bundle.
It's a table. And what the learned judge below accepted and is set out in his judgment is that this scheme evaluation is against and refers to the strategy and the LIP as well. And you can see that in the criteria column on the left-hand side.
Where exactly are you reading?
I'm on page 551.
Yeah, I have
and
that.
I'm on underneath, if your lordship can see the grey column which says facilitating the passage of vulnerable road users. And
Yes, thank you.
Yeah.
Yeah. And what do you want us to read?
So there you can see that box
Yeah.
refers to the criteria that the mayor's to have regard to,
Right.
and it's the statutory guidance, the Traffic Management Act, and then below it talks about the Vision Zero, which is an integral part of the mayor's strategy, transport strategy, penultimate paragraph there,
Right.
which informs key objectives in the Tower Hamlets local implementation plan.
So is the submission simply this, that if the appellant loses ground one, and section 151 has not been breached, then so far as ground two is concerned, that raises really a question of fact. What was taken into account? And you point to this as evidence that it
It was
obviously
taken into account. If
taken
there isn't a duty, then it was taken into account.
I see.
Yes. And that's the way the
Yeah,
court
I think-
approached it.
I do have a question.
Well, I was just going. I assume you particularly rely on the last sentence on the last two sentences on the page. Mayor's transport strategy sets out key principles of taking healthy streets approach to public spaces, and it includes, and then it goes over the page.
Exactly, my lord.
Right. And is this what the judge said, in essence?
That's what the judge said as well. I can. I think that's more or less exactly what the judge said.
You don't, just to be absolutely clear, you're not submitting that it wasn't a legally relevant consideration. What you are submitting is that, as a matter of fact, it was taken into account.
Yes.
Right.
And the judge has reflected my submissions in the judgment there.
I see.
My lord, I wasn't going to say anything more about that, unless it's.
May I just check if my lords have any questions? It looks like not.
So then, if I can move on to the consultation point.
Yes.
My lord, forgive me. You had said that I had a bit of extra time because of the delay, and I can't quite recall what that took.
Yes,
me to.
yes. According to the agreed timetable, by my reckoning, you must finish by 10 to 4.
10 to 4. And that's with the additional.
And that's not obligatory. You don't have to take the time if you don't need it.
I'll do my best. My lord, on the consultation point, actually, I will take that invitation to be quite short. My lord, this, even when permission was granted, it was said to be just persuadable. My lord, I would say that the judge below got this, addressed this matter entirely correctly.
Right.
There's no submission being made by my learned friend, Mr. Wolf, that the judge applied the wrong test. It's not being said that he applied the wrong law. And that's quite important. I would submit that means that your lordship should be quite cautious in...
Well, I see the force of that point, but I think we do need to be a bit careful because it's well established that whether there has been procedural fairness or not is a question of law. It's not, for example, to be assessed by reference to a standard of rationality.
No.
That's Osborne, but many cases have said that before and since. And so if that's right, then I'm certainly aware of cases where the Supreme Court has said, contrary to what the courts below had said, we decide this is or isn't fair.
Yeah.
So I don't think this is one of those situations where our role as an appellate court is limited simply to asking whether, for example, the judge below made some error of principle or something of that sort. I think we have to decide whether there's been fairness.
Yes, I think so, but my lord, what I would submit is that you have to do that within the principles that have been set out by various judgments.
Yeah.
In this particular case, what Mr. Justice Fordham did was he looked at those principles and he concluded that the third option was a derivative, had derived from the consultation responses, and he thought that that was foreseeable. He thought that that was gunning principle for operating, and that is, in my submission, that is entirely right. He says that at paragraph 60 of his judgment.
Yes, thank you.
That's the key section there. He makes the points which, in my submission, are difficult to gainsay. Consultation, he says, is not a process where everyone gets to comment on what everyone else says, or where everyone gets a right to reply or respond to a minded to decision. And that is essentially what the appellant is saying, that they should have been able to comment on this, and not only comment on it, but come out with a third or fourth or fifth option.
Can I ask you this, Ms. Shea? Suppose the mayor had decided that he liked option 3, and so the eventual option which was adopted was in fact one which the public had never been consulted about. Would that have been fair?
Well, in my submission, it probably would have been fair, because it is not, and that's a good way to test it, if I may say, because that is a far more likely scenario where something might not be fair, because that would actually be an option that was adopted and would have an impact. But I don't think probably even that would be unfair, because it derives from the consultation, it's a product of it, and it is not particularly different. Mr. Justice Fordham sets out the differences, and the only distinction really is the retention of Can Robert Street, one of the one-way roads, and also the use of ANPR cameras. That's the difference. Otherwise, it's very similar to option 1, removing. So in my submission, even that wouldn't be. But far, far less so in this situation, where it wasn't adopted at all. It was reasonably foreseeable in any case, and my lord can see that from the correspondence that's been put into the bundle. This is correspondence with the group that the claimant is a member of. It's in the supplementary bundle. Tab 13, and it's SB 436.
Thank you.
And well, there are various places. I mean, this is a series of emails sent between Save Our Safer Streets and the council's officers. And if you start from the back, really, SB 462, it goes in reverse order. But to start with, the council was inviting Save Our Safer Streets to meet, and Save Our Safer Streets were complaining, saying that we want to have a genuine opportunity to be listened to, and so on. And then you can see at page 458, at the top of that, you have a response from the council's officer. I can assure you this is a genuine opportunity to input and to be listened to in this process. Any input from other stakeholders will be considered as part of the process of developing, recommending a final scheme to decision makers. So it's quite clear what's being said. Process of developing and recommending a final scheme. You will be aware that part 4 of the gunning principles as a product of consultation is conscientiously taken into account. And then the next paragraph talks about proposals being at a formative stage, and other correspondents would take part in that. And then, my lord, other parts of this correspondence make it clear that the question of ANPR was widely discussed throughout. There was discussion about putting forward an option 3 so that everyone could sort of design a scheme together. That's obviously not how it works, but that's what this group wanted. And when your lordships have a chance to, I don't know if you have had a chance to.
Sorry, on the ANPR point, can you just show us, if you like, the best piece of evidence which shows that?
Yes, my lord. Paragraph 9 on page 439. And what you have to understand about this correspondence is a note of what happened, then it's minutes from Save Our Save the Streets, then it's a disagreement by the council as to what those minutes reflected, and then it's a further set of correspondence from Save Our Save the Streets saying they're right. But throughout those, there's reference to ANPR, and you can see that paragraph 9 on page 439. And you can see a discussion throughout there about ANPR.
Is the submission you're currently making that there was no material prejudice
Yes, well,
to this appellant because everything that they wished to say was said and taken into account? Or,
Well,
are you making some other point?
no, I'm not. I haven't really got to that point, my lord.
I see.
My point really is that dealing with Mr. Justice Fordham's point about it being reasonably foreseeable that there
Oh,
would
I
be a
see.
new scheme or a product.
I see,
Yeah.
right.
And the objection that's being raised by the appellant is that the camera issue wasn't put forward. That's the point. So the camera issue was aired. It was foreseeable that that could come forward. But also, in the officer's report, it's obviously necessary for the council to take into account all consultation responses, and that's a point that Mr. Justice Fordham makes as well.
Yes.
There is discussion there about ANPR as a response from Tower Hamlets waste collection.
Where's
And that's
that?
at 3.24 on page SB 472. Then, my lord, just
Oh, yes.
the final point on this is that real-world perspective, again, that Mr. Justice Fordham referred to, which was that the suggestion that this was somehow going to be a unifying approach is obviously not borne out by the letter sent by the claimant, the appellant, to the council, which was that this option would immediately and significantly increase road danger in Bethnal Green. And part of that letter is quoted in Mr. Justice Fordham's decision, but we did send through the full letter. I don't know if your lordship's got that.
Can we just go back to this foreseeability point? The judge may be right. I don't know. We'll have to think about that. But I'm just wondering whether we can really lay down a proposition of law that's for that reason.
No, I think...
I'm very conscious because we have to keep an eye on the whole of public law,
Yeah.
not just this particular. I know this case is very important to everyone in this courtroom and beyond, but this court has to keep in mind the shape of the law more generally.
Yeah.
And the consultation is required in many, many different contexts, including the preparation of draft legislation. So, and leave aside primary legislation where different considerations may come in because of the sovereignty of Parliament, but often you get secondary legislation. And there's a consultation period. And let's say that a government department consults on options 1 and 2. And extraordinarily, somebody in the public comes up with a brilliant option 3. So the government then proceed to legislate implementing option 3. Well, on your submission, are they entitled, in fairness, to do that?
I apologise if I didn't make this clear. It depends on the degree of change.
Yes.
It obviously can't be the case that something completely different is put forward.
When you say that, but I'm wondering why not? As long as the consultation period has been complied with,
Yes.
as long as all the gunning principles have been complied with, if, as my lord was saying this morning, if what's happened is that they come up with option 3 in consequence of the consultation,
Of course, yes.
Why do you have to keep going
you don't.
round and round consulting?
No, I think there's a difference of point here. If the option 3 or 4 or 5, whatever comes out as a product of the consultation, then I don't think there's any obligation to reconsult and then reconsult again. There's a never-ending round of consultation. That is not the purpose of consultation. And this is quite clearly set out in the Keep Withenshaw special case.
Right.
And in particular, that's at tab 16.
Sorry, can I just get that?
These sort of points are all made there. And there is paragraph 75 and 76 and 77, page 306.
Let me just get that. 75 to 77.
That's right.
Thank you very much.
And again, it makes the point at 75 that you need to look at the order of differences between the proposal, the material consulted on, and the decision the public body in fact intends to proceed to make. Now that goes back to the point that they didn't actually make that decision anyway, but applying the principle. The last 3 lines make it clear that the examples serve to illustrate the very high order of the significance of any difference which would warrant reconsultation. And then 76 makes the point that the fact that the 3rd line down, finally, the fact that a change arises so as to reflect views produced by the consultation process does not in itself require a consultation. Once again, it's the extent of the change. If the change arose from the original consultation, that is simply evidence of the 4th Sedley criterion in operation, and not in and of itself a reason for reconsultation. It's the extent of the change that requires examination. So this is consultation working. It's listening, the council's listening, and the judge makes the point, it's conscientious consideration by officers. That's what's happened here. And then the dangers of the approach being put forward by the appellant are set out at 77. Decision makers will have a broad discretion as to how the consultation exercise may be structured. And the point in quotes there from the Greenpeace case is that there are always going to be ways to improve a consultation, but that's not the test. There may be many ways of doing a consultation. The test is whether or not something has gone clearly and radically wrong. And we're nowhere near that in this case, in my submission. All that's being said is that the appellant would have liked to have had...
That appears to be an internal quotation from some other authority.
The Greenpeace case.
No, it's a quotation from Greenpeace, but then I see it's in single quotes, clearly and radically wrong.
Yes.
Do you know where that comes from?
That's
Don't worry if you don't.
Well, off the top of my head.
No, that's fine. We can find it. Can I just ask you for your assistance with this? The test is whether the process was so unfair as to be unlawful.
Yes.
Has that been approved at the level of the Court of Appeal? So, if I may say so with respect, it seems like many concepts in public law to be tautologous.
Yes.
It's like so unreasonable that no went to spree.
Yes. I suppose that's why we're here in the Court of Appeal dealing with the point, I suppose. Because
Anyway, again, if anyone knows if this is vouchsafed by the Court of Appeal, then of course we're bound by it. But I'd just like some assistance on that.
we will check that.
How about the JL case that's cited after the quotation, just before 78? Lord Justice Sutherland confirmed the test is whether the process was so unfair as to be unlawful.
Yes.
Well, the trouble is that's an administrative court reference, EWHC.
Yes.
Ah, yes.
And he may have been sitting in the divisional court.
Oh, right, yes.
Yes.
It may not matter, and obviously all of these statements need great respect, coming as they did from a very great judge. But if anyone can assist,
Yes, we will.
because obviously anything we say sets a binding precedent.
That's noted. That's understood. But my lord, just looking at...
Sorry. On something you were saying before, I'm just looking again at the judgment at paragraph 60.
My lord, this was Justice Fordham.
Yeah. Which is on page 48. And we've looked at those words foreseeable exercise, which you've made some submissions on. But I noticed that he goes on to say, 5 or 6 lines up from the bottom there, it was a foreseeable exercise, properly derivative of the consultation. So the judge seems to be saying there that it arose out of the consultation process that did take place. And just looking at the top of the paragraph, he also seems to say there that Mr. Wolfe had accepted that where, on another point, something was derivative of the consultation, that wouldn't be unfair.
Yes.
So that seems to be the way that the judge reasoned it, as I see it.
Yes. And that was to do with the road Can Robert Street, which was originally slated to be removed under option 1. But that was then an example of the mayor listening. It was derivative because there were various consultation responses saying that was a very useful closure. And so it was kept in the same way as walking. And my lord's quite right, that was accepted. And in the same way, the compromise proposal that was put forward for option 3 was derivative of the responses that came out of the consultation. And that is the consultation process in my submission working. That is not reflective of anything unfair. And there is no prejudice either to any party. This wasn't actually adopted. It wasn't adopted, so there's no prejudice.
Well, can I ask you the question that I posed earlier? Suppose there had been consultation on option 3 and 90% of the respondents had said, we really like this. Is it possible that that could have been an important factor in the mind, potentially, of the mayor?
No, my lord, I think that's the danger, I think, of trying to perfect something. The question, if the test is so unfair as to be unlawful, and applying the principles, what is required is a consultation with an open mind at a formative stage. I mean, the gunning principles have been endorsed by the Court of Appeal, of course.
And the Supreme Court.
And the Supreme Court. So that's what's required here. That consultation took place, and it was not unlawful for the mayor to make a decision based on those 3 options that were put forward. That's his job. It was his job to make the decision. And he had the correct information before him. The question of divisiveness, I mean, there's no reasons challenge here now or irrationality, but divisiveness was a matter where the mayor decided, even though there was support for both of those the other 2 options, where he decided that he wanted to start again, he wanted to start completely afresh, and that's in the judgment as well, and that's in the minutes, his statement. So it's unlikely that would have made any difference, but that's not the point. The point here is, was it unfair? No, because it was a derivative. There's no requirement to keep on consulting round and around. There was a fair consultation, the correct information was gathered, 3 options were devised in order to assist the mayor quite properly, and that doesn't give rise to unfairness in consultation.
Thank you. Did you want to say anything further beyond what you've already said in writing on material prejudice?
My lord, I think not beyond what I've said.
Fine. That's fine. Just wanted to make sure you've had the opportunity to cover everything you wanted.
Yes, I've made the points in there, and of course I rely on the judgment as well.
Yes.
So, my lord, unless
Can I
I can
check if there are any other questions? It's very helpful. Thank you. Yes. Now, who's going next for reply?
It's me.
And again, can I emphasise to this side of the courtroom that just because adventitiously there's more time, don't feel obliged to use all of that time.
No, my lord. I only wanted to respond to the points being raised by my known friend in relation to grounds that I deal with. First, in relation to ground 1, reference was made to section 16 of the Traffic Management Act 2004. I'm not quite clear in what way that related to my learned friend's case, but the judge for completeness dealt with the relevance of section 16 of the 2004 Act, at paragraph 29 sub 1 of the judgment. There's no respondent's notice, and I would respectfully ask the court to be astute to the fact that there's no respondent's notice, in my submission various points were, as it were, dangled by my learned friend in front of the court, but ultimately the court at 29.1 found that the existence of other statutory duties such as section 16 made no difference to the analysis.
Well, I think the submission that Ms. Shape makes is that she now accepts, although she did not below, that section 16 does not enjoy a hierarchical primacy over section 151. But what she still maintains is the converse. Section 151, she submits, does not enjoy any hierarchical primacy over other primary legislation either.
Well, my lord, that may well be the case, but as I say then, in that situation, I'm not sure what that adds or takes away from the issues that are before this court.
Right.
In my submission it doesn't, but in any event, section 16, as is recorded at paragraph 29.1 of the judgment, makes clear that the duty in section 16 is subject to other obligations, such as the Greater London Authority Act and the rights and obligations within it. Section 16 is a broad power which must be exercised lawfully, and therefore lawfully in accordance with Part 4, Chapter 1 of Part 4 of the 1999 Act. But my lord, for the purpose of my submissions, I simply rely on what the judge says at paragraph 29.1, and it doesn't take the analysis any further so far as the issues that this court needs to decide in terms of the...
Can I ask you this question? The way he expresses it is of some interest, because, as you rightly point out, he says that the fact that MTH had duties under sections 16 and 17 under the 2004 doesn't provide him with lawful authority to choose to contravene, and I'll omit the next words, section 151, but then coming back to the words that I've omitted, a statutory duty arising under. Now, can I ask you this question? Do you contend that what the Mayor of Tower Hamlets has done in this case is to contravene a statutory duty arising under section 151?
Yes.
Right. And would you accept that entails consideration of whether that's an enforceable statutory duty?
Well, that comes back to the issues that we were canvassing at the outset of my submissions. But what section 16 says is, and so far as it's relevant to the section 16 issue, that the general network management duty, as is recorded, is to manage the road network to secure expeditious movement of traffic, so far as may be reasonably practical, having regard to other obligations, policies and objectives. And so the duty, insofar as it exists in section 16, can only be exercised insofar as it would not contravene any of those other statutory duties. Now, if there were a breach of section 151, what that act is saying is you don't need to do anything, or your duty to manage the road in a particular way, you're not required to exercise that duty in a way which would contravene your section 151 duty. Whether the duty in 151 is enforceable as a statutory duty is not strictly relevant to the way in which the issue arises under section 16.
That seems to be, at the moment, to be central to the question of whether the judge was right or wrong, because let's assume that the duty under section 151 was enforceable. Then you would have an open and shut case, because you would say there's a clear statutory duty here. Not only that, as is accepted, section 16 expressly is subject to other obligations, and so you can't, as the Mayor of Tower Hamlets cannot, under section 16, contravene an enforceable statutory duty under section 151. But your answer to my question, as I understand it, is it doesn't matter if it's enforceable or not. And I'm a little puzzled by that. Why doesn't it matter?
Well, section 16 is, as it were, a broad duty expressed in very broad terms. And all that section 16 is doing is saying that you can exercise this duty, and you've got a duty to manage the road network in the way that it describes, so far as may be reasonably practicable, having regard to other obligations. So insofar as it's not practicable to do certain things because you would be in breach of a statutory duty such as section 151, you're not then obliged to do whatever it is you would do under the section 16 duty.
Yes.
I think that sorry, Mark.
Forgive me for interrupting you. I may have misunderstood the judgment, but as I read the judgment at present, 5 lines from the end of subparagraph 1, there's this important sentence. It means the general duty is qualified by other obligations. And that's what the judge said. And as you say, there hasn't been any respondent's notice to say either that the judge was wrong there, or to say that the section 151 duty is not a relevant duty because, for example, it's not enforceable. That's certainly not the way the case is put for the respondent, I think.
Well, I'm sorry to interrupt, but just to be very clear, this paragraph 29, is the appellant's analysis that's being set out here. It's not, I think, the findings of the judge himself.
No, I don't agree, I'm afraid.
No.
He is specifically rejecting any suggestion. Within the previous sentence, he's dealing with a possible interpretation of section 16, which is that other statutory obligations are merely legal relevances, which could then be breached. He's saying, no, the general duty is qualified by other obligations. And then, as I understood it, maybe I've misunderstood, and this is only part of their analysis.
Well, no, it's at the top there. It says, at paragraph 29, the sentence before 1.
You know,
their analysis had these key statements.
I do understand that, but then he says in the final sentence of that subparagraph, you were wrong to claim a hierarchical primacy. And then doesn't the judge go on to say, that I accept stages 1 and 2,
Yes,
paragraph 31.
Paragraph 31.
Yeah, and the way it comes back in is then at paragraph 34 at the end,
Yeah.
where he says, law beside which the defendant's traffic management duties, not a question of those overriding the section 151 duty, it's a question of the public law citizen. So that's your submission in this court.
Yeah.
Thank you.
Thank you.
Can I just ask a very, pedantic question? Does he mean legal irrelevances above the sentence my lord just read out?
No, I think he does mean
That does
relevant.
not
Yeah,
mean
this is...
that other statutory obligations become...
Because I think what he's getting at is that where it says having regard to, could simply be regarded as being the public law obligation to take something into account. And he's saying in this context, it's a much stronger obligation than that because the general is qualified by the specific.
Yes.
I think.
Yes, he's not saying you need to take these into account and then breach
Right,
them. He's saying you actually need to not breach
I see.
the duty that's being referred.
Can I come back to the question I was asked? Because it comes back to what the judge says in paragraph 33. Because his final sentence in that paragraph is table 18 does not provide the content for the scheme which could make it an enforceable statutory duty. Now, as I understand it, your answer to my previous question is, well, he's asking himself the wrong question there. Because you say it doesn't have to be enforceable.
No, that's not what I'm saying. I'm saying for the purpose of section 16, the section 16 duty, such as it is, which is a very broad, high-level duty, is caveated with the words in the...
Sorry, my question is not about section 16. Because that point has been answered in your favour, no respondent's notice, That's the end of that, really,
Yeah.
save to the limited extent that it comes back in at the end of paragraph 34 of the judge's reasons.
Yeah.
But what I'm interested in is the duty arising under section 151, which is what you are relying on.
Well,
And the judge's first reason, which you're attacking, is about enforceability, to which a key part of your argument is it's not enforceable, as I understand it. And yet you seem a little reluctant to confirm my understanding.
No,
that's what I'm trying to
I'm
tease
sorry,
out.
that's my confusion, because I thought your question arose in the context of section 16. No, our case is very clearly that this is an enforceable statutory duty.
Right.
And
So I thought your case was it doesn't have to be enforceable.
in the context of that was in the submissions I made were relevant to the way that one approaches section 16 and the caveat which is in the inverted commas. So in terms of the way that you exercise your section 16 duty, you have regard to other legal obligations.
Yes.
Or enforceability or otherwise of statutory duties is not relevant to the way in which you exercise your section 16 duty in terms of that caveat. But in terms of the primary case we make, yes, it's an enforceable statutory duty. Paragraph 33 is concerned with the timetabling issue, and I've addressed, you have my submissions on that. I'm not going to repeat myself, but ultimately we say that this is an enforceable statutory duty, and all the judge is saying in the final sentence of paragraph 33 is this is not an enforceable statutory duty by reference to the content of the lit. And we say that was wrong.
Can I just say, so I want to be clear before this hearing concludes, I have not understood the respondent to say to this court, section 151 is not an enforceable statutory duty.
No.
I have understood the respondent to submit that they complied with it.
Yes.
Because of the correct interpretation of it, particularly the point that implement does not mean retain.
Yes. That's very clear. My Lord, in a similar vein, my learned friend referred to the public sector equality duty. I'm not clear what precisely that relevance have to any of the issues that you need to decide. But for completeness, the public sector equality duty in section 149 of the Equality Act is a have regard duty. The council here had regard to the potential effects on those with protected characteristics as a result of all the options, retaining, removing, and so on. That's 603 of the supplementary bundle. It's addressed in the officer's report at 488.
Sorry, don't take it too quickly. 603.
603 is the EI Equality Impact Assessment,
Yes.
and the relevant pages of the officer's report are 488, 489. There's nothing in the documents to suggest that the respondent was driven to make the decision that it did in order to comply with section 149, or that by making a decision to retain the scheme, that would breach section 149. Again, I'm not entirely clear what relevance section 149 has.
I think the point is simple. That section 151 cannot have the effect that, come what may, in the future, they have a duty to implement everything which is in the LIP, because the manner in which various steps may have to be taken to implement the LIP include processes like consultation. They require, and that has to be done with an open mind. It requires things like compliance with the public sector equality duty in section 149 of the Equality Act. And what Ms. Sheikh is saying is simply, if we go into those exercises with an open mind and do it conscientiously, we can't guarantee that the outcome will be that we are going to be able to implement. Now, I think that's the relevance of it.
My Lord, I'm grateful for that indication. The long and the short of it is not uncommon for statutory duties that to need to be exercised in a way which is consistent with other legal duties. So there's nothing in principle objectionable or should be of any concern in the fact that section 151, insofar as it imposes a duty, would need to be understood subject to those other legal duties. On the facts of this case, there's no concern that there would be any potential breach of the public sector equality duty. Indeed, that was expressly considered by the respondent in this case. It's never been part of the respondent's case to suggest that there would be any breach or other concern by reference to the public sector equality duty. That was an issue which was raised for the first time in Learned Friend's oral submissions before you. I turn then to the question or the issue of the fact that schemes within the LIP would need to be implemented by reference to road traffic regulation orders, or here, in the first instance, experimental traffic orders. In my submission, it's important to understand the difference between the policy decision in the LIP and the policy measures which are in the LIP in order to deliver on the Mayor's transport strategy, to which the duty in section 151 attaches, and the mechanism by which individual schemes will be implemented. And it's right that individual schemes will need to be implemented, and the respondent had a choice. There are a variety of mechanisms it could use, whether an experimental traffic order or a permanent traffic order. It chose, in this case, to implement the measures initially by experimental traffic orders and then convert them into permanent orders. But the fact that those implementation measures have public consultation attached to them is neither here nor there in my submission in terms of the strategic duty which is in the LIP. On the facts of this case, it simply doesn't arise because those schemes were put in place pursuant to that mechanism, and the question is not whether there is a duty to put in place schemes which would be contrary to the outcome of a TRO consultation process. The question here is whether, having put those schemes in place pursuant to those mechanisms, you can remove the scheme. So in my submission, that issue simply doesn't arise on the facts and wouldn't, in any case, prevent the duty from arising. I should just make one correction to what my learned friend says, which is these schemes were put in place by way of an experimental traffic order. The way, if the court wants to have regards to the relevant provisions, the way in which it works is you put your experimental traffic order in place, and then during the currency of the experimental order, you consult people, and so they are able to live the real world effects of the experimental order. You consult during that period, and then you make a decision, and it's Regulation 23 of the 1996 regulations, which says you make the order permanent, but you need to have regard to the consultation that you carried out during the period of the experimental order. It's not the case, as my learned friend suggested, that you make your experimental order and then you make a permanent order pursuant to Regulation 6, which you would otherwise do if there hadn't been an experimental order. So I just want to, I don't think it makes any difference to the analysis, but just to make sure you've got the correct position. And then final issue on ground one, my own friend referred to the fact that schemes have been removed elsewhere in London, and a number of boroughs were referred to. In my submission, that's wholly irrelevant to the issues which should concern you. The claimant doesn't live anywhere else in London. The claimant lives here. This is the scheme about which he is concerned. The fact that other schemes may have been removed in breach of statutory duty elsewhere in London, it does not provide any reason in my submission for the court not to take action in respect of that breach if it's satisfied, of course, that there is a breach. And it's, of course, the case that there may be lots of decisions which are taken unlawfully which happen never to be challenged. And that doesn't mean that you don't then take action when a decision is challenged. So in my submission, that point is wholly irrelevant to the issue. I want to then turn to respond briefly to what my learned friend said in relation to ground 2. You were taken to Appendix D of the officer's report and the table which appeared at Appendix D, and that's at Supplementary Bundle 551. And in particular, my learned friend relied on the final 3 lines in the left-hand box and what's written over the page as well as the paragraph above, but the final 3 lines refer to the Mayor's transport strategy sets out key principles for taking a healthy streets approach to public spaces. These key principles include, and then various principles are set out in the bullet points. That is the extent of the respondent's consideration of the content of its own local implementation plan and the content of the Mayor's transport strategy. There is nothing in the body of the officer's report at all. It's only in this appendix, and it's only this brief reference. And I say what the respondent didn't do, which it was required to have done, was to recognise that the scheme that it was proposing to remove was identified expressly in its local implementation plan as a proposal, which had been and was required to implement, that proposal was integral to two of the Mayor's transport strategy outcomes as part of his overall strategy of healthy streets. Simply referring to the principles in general without recognising that the removal of the scheme would contravene the LIP and the Mayor's transport strategy, in my submission, simply wasn't enough to demonstrate that he grappled with the issue at play here, which was that the removal of this scheme was so obviously contrary to the LIP and the Mayor's transport strategy.
There are a couple of other references on there. I'm just looking ahead in this document. It's not quite accurate to say this is the only...
Well,
if it's the same document, but for example, is it the same document at 554?
So it's right to say that it's repeating the same. So you see the way that this document works is to review first option 1 on 551 to 553, then option 2, and then option 3. But as it were, the relevance of the same words, as it were, are copied and pasted into the evaluation in respect of each option.
Well, some of them are.
I may have...
It should be a bit different, but anyway, we can look at that. But the one on 554 looks a bit different from... Maybe it's not.
I'm not sure that it is, but I may be wrong about that.
551.
And then there is, for completeness, then on 556 over to 557, there is what I think is a copy and paste, but I may be wrong again about that. But I think they are simply identical references. In any event, the same submission that I would make about grappling with its removal applies to each of those 3 points. My learned friend, finally then, my learned friend said by reference to evidence that she referred to, and the court was astute to say there was no respondent's notice on this point, was that by removing this scheme, the respondent wasn't going against the Mayor's transport strategy anyway. Well, with that, and that is obviously wrong, because section 151 is tied to the proposals in the local implementation plan. This is the removal of the proposal, and so it's not a question of whether the Mayor is otherwise delivering upon the Mayor's transport strategy, that judgment being exercised in the round by reference to everything that the Mayor is doing in Tower Hamlets. The question is this the removal of a scheme which is in the LIP? And it obviously is. It's therefore obviously contrary to the LIP and obviously contrary to the function of the LIP in delivering the Mayor's transport strategy. So it's wrong on the facts as well to make that submission. Thank you, my lord. Unless there's anything I can help with.
Check. Thank you very much.
Because of the LIP point, we've agreed that I will follow on, and then Mr. Wolfe will follow. My lord, I just want to address, first of all, the enforceability of section 151 and the TfL's position on that. TfL's position is that section 151 is, by definition, an enforceable statutory duty. It must be, on the legislation, and the enforceability of it arises as soon as the Mayor approves an LIP under section 146. That is a judgment which the statute has reserved for the Mayor. Once it is exercised, then the obligation to implement arises under section 151. That is the statutory scheme.
Can
And
I,
it then
can I
becomes-
ask you this question?
yes.
I mean, it may be that the misunderstanding between myself and Mr. Parker arose out of using the word enforceable in two different senses. Because, as we discussed this morning, when it comes to stage 6, the judge proceeded on the basis that the court had jurisdiction on judicial review to enforce the Section 151 duty. And although that seems to be only an assumption, there's no respondent's notice saying that that was a wrong assumption. So let us take it that for our purposes there's no dispute that in that sense it's an enforceable duty. But one then asks oneself, well, what did the judge mean, given that assumption, when he says in paragraph 33, Table 18 doesn't provide the content of the scheme which would make it an enforceable statutory duty. And that may be distinguishing between enforceable as a generality, which is the stage 6 point,
Yes.
and enforceable as to the specific content of a particular scheme.
Yes. Well, I think he is doing that. I think that is the correct analysis of what he's saying at paragraph 33. It's unquestionably an enforceable statutory duty because of the assumption at stage 6. He concludes...
Is it your submission that he's wrong in that second stage of his analysis?
Yes, he is wrong in the second stage of his analysis for 2 reasons. He's wrong because it is not for him to judge whether Table 18 meets the statutory criteria in Section 146. That judgment has been reserved for the mayor, applying the conditions in Section 1463, which are that the proposals must be adequate for enforcing the mayor's transport strategy, and the timetable must also be adequate for that purpose. In other words, the mayor's transport strategy. That judgment is the mayor's. The mayor's judgment has not been challenged by any application for judicial review. It was taken in 2021, and there it is. So the table is sufficient for the purposes of enforcement for Section 151. Now, what there may be, I accept in principle, although not in practice, not in this case, but in another case, is that you could have a question arising about when the duty becomes enforceable. In other words, when there's been a breach, according to the timetable that is set out. But that doesn't arise here because the scheme was implemented in accordance with the timetable according to the respondent's own evidence, and you were taken to it this morning by Mr. Parker. Mr. Baxter says we implemented the scheme within the timetable in Table 18. So for all those reasons, the judge's conclusion at paragraph 33 is wrong. It's wrong in law and it's wrong in fact.
Can I just ask you about the first of those propositions, that it's wrong in law? As I've noted your submission, you've said that that judgment is one exclusively for the Mayor of London, not for the court. Can I just ask about that? Because if a case is brought by way of judicial review, why doesn't the court have to decide whether a duty that it's being asked to enforce has been breached or not?
Well, because it hasn't been asked to assess whether that is an enforceable, whether Table 18 is enforceable. It's not before this court, wasn't before, it's not in any of the pleadings. There's been no challenge by the respondent.
Well, that's a different point. That's not a point of law. That's just a happenstance and the way this case has been argued.
Well, I may have put it, I may have overstated the point. The point that I'm making is that there is a decision that has not been challenged. And so in law, oh, so sorry.
No, sorry, it's my fault. You carry on.
So in law, as the matter stands, until that decision is challenged,
Yes,
that's what I meant.
I see.
I may have misstated, but
No,
what I meant is that
that's helpful.
in law, as things stand, without a challenge to that decision and a conclusion that it is unlawful,
Yes, sir.
Table 18 is enforceable.
So, and so as I'm crystal clear, the decision you've just referred to is the Mayor's decision when approving the LIP?
Yes.
Yep.
because it is the mayor who decides whether it's adequate. And when you look at the end of paragraph 33, the judge appears to be saying, well, it's not enforceable, but it must be.
Yeah, but I'm still struggling slightly, because it's not in dispute that there's no challenge to the Mayor of London's decision to approve the LIP. But I thought you were asking a question that my Lord Justice Singh had put about a decision to enforce the duty under Section 151. And I'm not aware that the Mayor of London has taken any decision on that, has he?
No, he's taken a decision to approve the timetable.
Yeah.
Under Section 1463. So it is it may be enforced. In other words, we are now in Section 151 territory.
Yeah, but I thought you told us earlier that the reason why the judge was in error was because he'd asked himself the wrong question.
Yes.
And it's that submission I'm just trying to explore a little bit, because the whole thrust of your submissions earlier was this is about an unlawful decision taken by Tower of Hamlets. But the question depends to some extent, or on one view could depend, certainly on the judge's view, seems to depend to some extent on the extent to which Section 151 is enforceable in the specific sense rather than the more general sense that the court has jurisdiction to look at it by way of judicial review. And my Lord was asking you a question that was arising out of your submission that, well, that's a matter for the Mayor of London, it's not a matter for the court. And what I'm trying to get at is, but there's been no decision by the Mayor of London to enforce. On the contrary, it's your own case that he doesn't need to take any to such decision because that's not your ground of objection. Your ground of objection, or supporting the claimant's ground of objection, is this is an unlawful decision by Tower Hamlets.
Yes, I maintain everything I said before. Because I'm standing here, we're looking at this statutory scheme for the first time. And there's been a lot of discussion about how Section 151 works, how it interacts with Section 16. I'm making submissions about how, from the TfL's point of view, the Section 151 duty becomes enforceable. It remains my position on behalf of TfL that the key question before this court, as arising out of the way that the case was put below, is whether the decision to remove was unlawful, and that it was unlawful because the respondent did not go through the clear statutory steps that are required to be gone through before you remove a scheme, which is related to Section 151, but in fact is, as I explained by reference to TfL's skeleton argument in the court below, is largely looking at the mechanism for revisions to LIPs. So that remains at the nub of the case as I characterise it. The judge looked at it from a different angle, and you, my lord, were asking questions about that earlier, and I simply wanted to respond to that because partly because of the brevity of the submissions today, I have not had a chance to go through the scheme and set out TfL's position on how it works. And I just want to make it absolutely clear that from TfL's point of view, or rather TfL's submission, is that the way that the Section 151 duty arises, and when it arises, is after it inexorably flows from a decision to approve under Section 1463. Once that occurs, if that decision isn't challenged, then there is an enforceable statutory duty. It was for that reason that the respondent proceeded and did implement the scheme, and the respondent has now made a decision to remove it. And the key question that has been canvassed in court today is whether that decision was lawful. And TfL's argument about that is that it was unlawful because it didn't go through the proper procedure, which is to apply to revise the LIP.
Thank you.
You may be right about all of that, and I don't want to prolong this debate, but as you say, this legislation, as far as I'm aware, has never previously been considered by this court. So I think, speaking for myself, I think we're going to have to be very careful not to say anything which doesn't have to be said to decide the case in front of us. But since you've raised this more general point, speaking for myself only, I still have concerns about the breadth of the submission, because suppose the mayor has made his decision and he approves a LIP which contains all sorts of vague things in it without a proper timetable. And then somebody comes along to a court of law and says, look, no one's challenged that, so this is an enforceable statutory duty, and we want a mandatory order from the court enforcing it. Now, speaking only for myself, I would be very hesitant about accepting the proposition that the court is then powerless to scrutinise with close care what it is that it's ordering a citizen to do, because breach of a court's order is a contempt of court and can lead to people being sent to prison. So when we make court orders, we need to be very precise. And if we thought, for example, as the judge thought here, this is all too vague because the content doesn't contain a proper timetable, etc., I'm not at all sure that we would grant a mandatory order. But I come back to where I began this intervention, which is that we probably don't need to go into any of this.
Well, it is absolutely my submission that you don't. And that's why I started where I did, agreeing with the point that you had made, my lord, about this being about a removal of a scheme.
Right.
And going...
All right.
And because, in fact, here we have a scheme that was implemented in accordance with the timetable.
Yeah. And those are points you made in opening, so...
I don't need to make them in reply. And the same applies to the consultation point.
Right.
Because, in fact, there was a consultation. The consultation did not lead to the revision of any of the aspects of the scheme, and the scheme was then implemented without any problem. So the consultation point that has been canvassed doesn't arise either. And I respectfully agree that until there has been a full discussion of these other issues, it would be better to leave that for another case. But in this case, none of those questions arise.
Right. I don't want to curtail your submissions
No.
in reply. Is there anything else you need to say?
I wanted, just on the discretion to revise at section 148, there was a question about whether the local authority, the breadth of the discretion to revise. I respectfully agree that in this situation, with your lordship's observation, this situation, an obligation would arise to revise. That is the case, the TfL's case, an obligation to revise because this is a significant change. And as my learned friend Mr. Parker pointed out, when you look at the way in which this decision was characterised by the mayor of Tower Hamlets, it was not characterised as just one removal of one scheme. This was a whole project and policy of removing low traffic neighbourhoods across the borough. This was a significant change of direction, and it therefore required, in terms of substance as well as because it contravened the LIP, a revision to the LIP with approval from the mayor in order to be lawful. So, and then finally, Ms. Clark has explained, this is TfL's witness, at tab 17, pages 716 to 718 of the supplementary bundle, paragraphs 51 to 57, the way in which TfL seeks to deal with removals of schemes or changes to schemes in other boroughs. The full facts and the full circumstances of each change will be taken into account by TfL every time it takes a decision about how to respond. It doesn't affect the lawfulness or otherwise of what the respondent is doing. And I should note that also at tabs 11 and 12 of this supplementary bundle, pages 428 to 435, you will see the letters in which TfL objected strongly to the removal of the scheme. It didn't mention section 151, but that is, as already explained, because in this case the scheme had been implemented. It was about trying to stop the borough from removing it and pointing out its inconsistency, the inconsistency of the removal with the borough's own LIP, and that's what you will see from those letters from TfL. So TfL's position has always been and remains that the removal of this scheme is unlawful and not consistent with the statutory regime. I don't have
May I check if there are any other questions?
Can I just ask,
Yes.
sorry. Could I just ask you to go back to paragraph 35 of the judgment? Because I think to some extent the discussion we've been having today is about whether the statutory scheme imposes, as it were, a duty to retain. And actually the judge seems to have accepted that it might do. His decision seems to be a bit narrower than that, because he says about halfway down, I would accept that implement in accordance with the timetable in 151 could involve an ongoing duty by reference to an ongoing timetable. His point seems to be that if you look at the LIP in this case, there's no reference to any ongoing activities, if I can put it that way. So he doesn't seem to be saying that 151, on its proper construction, 151 brings the shutters down at the moment of implementation. He seems to accept it's broader than that. He seems to be making a point about the LIP. Now, what do you say about that part of the reasoning? This actually seems to be the nub of his decision, as far as I can see.
Yes. Well, I had hoped in my opening submissions to be drawing the court's attention to the aspects of the LIP itself. We didn't have time to look at it, but the aspects of the LIP itself, the context in which it sat, in which it made clear that all of these proposals were to be, if they made any sense at all, they could only be ongoing proposals. So in other words, it was inherent in the type of scheme that was envisaged that implementing the proposal for a low traffic neighbourhood meant keeping it in place. Nothing else makes any sense. You don't need, when you're proposing, as the LIP did, with all the explanation that is there, and if you look at chapter 4 of the LIP, you will see how it sits together with the objectives of the Mayor's transport strategy, which are long-term and are about healthy streets, reducing traffic, saving lives, that it cannot sensibly be understood as anything other than implement and retain, because otherwise it wouldn't be a low traffic neighbourhood, it wouldn't be a livable neighbourhood, it wouldn't be healthy streets. It would simply be a set of construction that is then removed.
When the judge says, I think that would need to be spelt out in the LIP, he's saying, in saying that it needs to spell out that it must not only be put in place, but it must be retained.
Yes, he appears to be suggesting that what is necessary is that it says implement and retain.
I see.
And it is the case of TfL, but also of the claimant, that implement the proposal, bearing in mind that the proposal is for a low traffic neighbourhood. It's not simply for a set of installations, means that it should be retained.
Yes, and I was only going to make the obvious point, as we always say in this court, one needs to read everything as a whole and in context, and we can see from the next, the remainder of that paragraph, that what he's rejecting is this. He says, I'm unable to accept the logic that discontinuing, and then he mentions various schemes. So he keeps mentioning it's the discontinuance, and he says the Wapping scheme had to continue in order to avoid a breach of statute. The pausing of further projects was a breach. So I think you would say that's all consistent with your fundamental submission, that the way in which the judge has interpreted section 151 is to read implement to mean and retain.
To read implement.
Implement does not mean retain.
It doesn't mean retain. Yes. And
that's what lies behind.
That's what lies behind.
Yeah. It's not that the LIP
I see. Yes.
failed to spell out. Obviously, one can all imagine situations where it says you've got to do this, but it doesn't tell you by when.
Yes.
Or it misses out something crucial. And one can understand that might have to be spelt out in the LIP. But your submission is that in paragraph 35, when the judge says that would need to be spelt out in the LIP, the only thing that he's saying that needs to be spelt out is, and it needs to be retained.
Yes, that's all he means. Okay. But I should make one further point before I sit down, which is that he seems to have a problem with the idea that the end date is 2041. He expresses scepticism about how far away that is at the beginning of that paragraph. But in fact, when you look at the transport strategy as a whole and the way the entire LIP process is structured, that is the goal, and it is the TfL's goal.
Well, certainly those who practice in, say, planning and environmental law more generally, including road traffic schemes and the like, I mean, you're often looking that sort of time frame into the future.
Yes, and that is the whole essence. It is a long-term strategy to which there are a series of short-term proposals to begin the construction of healthy streets, which, as I said in opening, will ultimately culminate by 2041 in 80% of travel taking place by these non-vehicular methods. That's the goal. So you can see when you look at it that way that there is nothing strange about this at all. And in fact, both by reference to the LIP and by reference to the statutory context, implement proposals must mean implement and retain.
Right, thank you very much. Right, Mr. Hawes.
Well, I think I can be relatively just picking up my Lord's first observation to my learned friend, and we obviously agree that fairness is a question for the court, a question of law, so we don't need on this side of the court to show that the judge made some wrong factual finding. It's for the court to judge the question of the legality of the non-reconsultation for itself. So the second point, my learned friend took you to the way that the judge dealt with this, and he identified that option 3, he said, came out of gunning for operating, in other words, listening to consultation responses, and was somehow derived from consultation responses. We accept that it was in broad terms a reaction to some of the consultation responses, and let me explain what I mean by that. Some of the statutory services made points about if you're an ambulance, it's harder to get from A to B if there are road closures in place. That's the position. So to some extent, the officers were reacting to that. It wasn't necessarily a new point, because that had been a point back in the 2022 process, but they were, in that sense, reacting to things that they were hearing in the consultation. But that doesn't mean that option 3 was derived from consultation responses. There's no suggestion that any one or more people in the consultation process suggested option 3 or anything like it. I mean, my Lord contemplated, I think you put it as a government consultation. Imagine some bright spark comes up with something new that nobody's thought of. This wasn't that case. There was no bright spark who said, what about this option 3? Particularly when you look at what option 3 involves, it's a complicated package. 467, which is back in the officer's report, is the beginning of the section in which the officers explained 467 was the summary of it in bullet points, but then it was explained in much more detail in 480 and following, the basis for developing option 3. This was an evaluative, deliberative process by the officers, leading to a scheme which is not in any sense any one consultation response or anything close to that. It's a complicated package. And that's, if you like, a testament to what the officers were seeking to do. Whether they achieved it or not is a different question, but they weren't simply responding to consultation in that kind of way. And it also wasn't, it's obvious on the face of the documents, merely a slight tweak to option 1 or 2. It was a different proposal. I'll come back to the significance of that in a few minutes. The other question, the next question about the May dialogue, you'll remember the meeting that Malone Friend talked about, and there's an email exchange. First of all, can I just remind you of the ANPR context that sat behind that, because ANPR was one of the topics that was mentioned at that process. 562, you have, that was the consultation document, or one of the two consultation documents, which had explained, I showed you this morning just to remind you, that looking at what the options were being consulted upon, option 1, option 2, and then in the second and third column, but particularly the third column on 562, replacing physical barriers with cameras. Now, first of all, that isn't by any means all that option 3 comprised. It's to some extent a limited subcomponent of it. But what was clear at that stage was that the council wasn't taking this forward for consideration. They had, in effect, ruled it out. It was a discarded option in that analysis framework. We then look, first of all, at what the judge said about the May meeting. The only reference in the judgment to the May meeting is in paragraph 56 of the judgment. Last 3 lines of 56. Safer Streets had specifically been told in May 2023 that the defendant was not working on any option 3. Now the judge records that, and Malone Friend hasn't sought to go behind that. And that is derived from the document you have, page 447, in the middle of the exchanges. It's a complicated email trail that Malone Friend identified, to and fro on what was discussed at the meeting. But at 447, more or less halfway down the page, there's a Simon. Simon is one of the people at the meeting who's the head teacher of the local school. Simon, why not use ANPR? Could get quite far with time use of ANPR. And then a couple of paragraphs down, J, is your plan to find an option 3? No. Very clearly, very clearly. We're not looking at option 3. So the suggestion that somehow it's foreseeable that an option 3 comes forward, which includes but is by no means limited to some ANPR options, is just fanciful. So the judge's conclusion in our submission that this was a foreseeable outcome of the process that people could somehow have seen coming, foreseeable, and somehow have, in their anticipation of it, in an anticipatory way, supported something they had no idea was going to come forward, is, we say, just simply fanciful. Next point, the Keep Withenshaw special threshold or test, whatever it may be, for triggering fresh consultation when things change. My Lords, can I just remind you, my Lords have this at tab 16, page 278 of the bundle. This significant change test is not a proxy test. It's not a proxy test. The issue is fairness for the court in the overall process. But even within that use of language by the courts to some extent, has been a recognition that what one is concerned with is the nature and extent of any change. I've addressed you already in the last couple of minutes on extent of change. I made the point in opening that we're also concerned with the nature of the change. And the nature of the change here is an attempt by officers to identify something which is capable of addressing the aim of the scheme as implemented and addressing some of the concerns of those who have concerns about it. That is part of the nature and extent of the change, which we say, if this is the prism through which one is looking, or the spectacle through which one is looking at this question, triggers the need for fresh consultation. Or further consultation, I should say. Then, my Lords, the so unfair as to be unlawful, my Lord Justice Singh asked about that. thanks to the power of Mr. Parker's internet searching in court, we can offer you at least one, I think, reasonably good example, which is the West Berkshire case. You've got, shall I give you 2016 1WR LR 3923, and it's Lord Justice Dyson, Lord Justice Laws, and Lord Justice Tracy.
Right, can I just have the reference again?
Sorry, it's 2016 1WLR 3923, para 60.
6
There may well be other places.
60.
60, yes. There may well be other places as well.
Right.
And then finally, just to go back, the point my learned friend made at the end about foreseeability and Can Robert Street, because there was a paragraph in which I had accepted, or I'm recorded having accepted, and I don't resile from it, that the Can Robert Street was itself derivative from the consultation. Can I just remind you of how that works? If you go back to page 420, or 419, then 420 in the bundle, 419, supplementary bundle, I'm sorry, tab 10, this is the actual questionnaire which you would have completed. 419, the council is presenting two options. Tick, I support option 1, tick, I support option 2. But then over the page, 420, to what extent do you agree or disagree with the proposed changes set out in option 1? And it's broken down. And one of the sub-options you could agree or disagree with, as part of option 1, is removal of, amongst other things, Can Robert Street, and then there's 3 others mentioned in that same block.
Presumably you would accept that even there, Can Robert Street is bundled up with Punderson's Gardens, Teesdale Street, Clarkson Street and Old Bethnal Green Road. There isn't a separate question in relation to just Can Robert Street.
Exactly right, but it's what is clear is that unbundling, to use that word, and I'm happy to use that word, the overall package of what's in option 1 is clearly foreseeable, and so it's not a huge step to say, I'm going to tick, or I'm going to say, I'm going to tick those boxes to say I'm interested in Can Robert Street, and then come to page 423, which is any other comments to make on the options, and say when I ticked in relation to group 1 on page 420, the one I'm actually concerned to keep is Can Robert Street. That would be an entirely foreseeable, and indeed many people apparently took that option, and that's why the mayor was swayed by their views and retained Can Robert Street. That's entirely foreseeable. Nobody looking at these documents in my submission would have foreseen anything like option 3 coming forward, and that's the distinction. One is foreseeable, and people responded to it entirely appropriately. No question that would ever trigger a need for fresh consultation. That would be absurd. But our example, which is option 3, which is wholly different in scale and in nature and extent, we say triggered the fresh obligation to consult. Well, unless I can insist further, then I think those are all of our submissions.
Thank you. May I check if there are any other questions? We're extremely grateful to all concerned, not only the advocates from whom we've heard, but everyone who's contributed to the preparation and presentation of this case. We will reserve our judgments. Drafts will be circulated in due course to those counsel and solicitors whose details have been supplied to the court, so they can draw attention to any typographical or minor factual errors. Can I stress, for the benefit in particular of those who may not be familiar with the legal system, that that is not an opportunity to argue the case again. We ask the parties, so far as possible, to agree a draft order at that point. If agreement is not possible, then we will expect brief written submissions so that an order can be finalised, we hope, at the same time as hand down of the judgment, which of course is done without the need for a further hearing. Can I stress, as this court has done in recent years, including in the Counsel General for Wales case, that when the draft judgments are circulated, that is done on a strictly confidential and embargoed basis, and any breach of that embargo is taken very seriously by this court. Thank you.
My lord, you had asked for another judgment.
Oh,
right. So unfair as to be unfair.
Yes.
You've been given one. I don't know if you want another one.
You can give me another one if
Yep,
you like.
all right. It's another one where it's mentioned. It's Help Refugees in the Home Department and the Air Centre. It's 2019 EWCA 2727. It's paragraph 90.
Paragraph
90.
90.
90, which sets out a number of principles that can be gleaned, and one of them is that.
Very good. That's very helpful. Thank you very much.
Court rises.